Parties have submitted consent agreements proposing that we find that the aforesaid transgressions were negligent and order R&J to pay an administrative penalty in the total amount of $15,036 and the Goldenberg Group to pay an administrative penalty in the total amount of $8,250. The respondents have already submitted the payments. Additionally, both respondents have agreed to file any outstanding expense reports, and it appears that they have done so. Both respondents have agreed to timely file all future expense reports. Based upon my review of the facts, I am of the opinion that the consent agreement is the proper disposition for this case, and I would like to make the following motion. I move that this commission approve the consent agreement submitted by each of the following respondents and the investigative division and impose administrative penalties for failure to timely file expense reports for the respective quarters as follows. As to R&J Properties Group, LLC, an administrative penalty in the total amount of $15,036 for its delinquent expense reports for the second, third, and fourth quarters of 2009. And as to the Goldenberg Group, an administrative penalty in the total amount of $8,250 for its delinquent expense reports for all four quarters of 2007 and the first quarter of 2008.
And that is the motion. Is there a second to the motion?
Second.
It being second, the floor is open. Any comments, questions?
I have a couple questions on it. One is $15,036, $14 a day, and the other one is $50 a day. And I read here where it says consent agreements assess different amounts per day. How do you determine one was $14 and one was $50 a day?
I can speak generally to the process, and then maybe John will have a comment as to these particular matters. But the lobbying regulations give this commission, and specifically the investigative division, a great deal of discretion in negotiating settlement agreements for these types of penalties. And so, even though they're different amounts, I'm sure John can speak to what their factors were when they were looking at the two cases.
Let me just get back to those figures. So
Is 50 the maximum that you can?
Yes, per day.
Up to $50 a day.
$50 per day.
And RJ, we charge you $14 a day, and the other one was $50 a day. I support what we're doing.
the basis of it was to fit the fine into the scale. The actual basis of it was that the one was going to be a larger fine because they were delinquent for a longer period of time, and the type of lobbying in which they engaged was a more direct type of lobbying, actually contacting legislators and employees of the executive branch in an effort to obtain a $10 million redevelopment grant from the Commonwealth. It's called RCAP, grant from the Commonwealth of Pennsylvania, so there was a lot more direct lobbying. So, in effect, although the daily fine is less, the fine in total is bigger. And the reason that it breaks down into a daily fine is so that the commission has a legal basis in order to issue it. Because you do have that discretion within the range anywhere from 1 penny per day to $50 per day.
So, the severity of the offense.
It counts for the larger fine, yes,
Right,
for the lengthier term of the delinquency during a period when there was actually direct lobbying going on. In the second case, where you had the lower amount of money, the $8,000, there was only a 165-day delinquency, and there was no evidence of any real direct lobbying, although there was activity that needed to be reported on the expense report. There was no indication that there was specific contact with members of the General Assembly or the executive branch.
Okay.
So that fine was negotiated at a lower rate, $8,000 or thereabouts. But it breaks down into the category of you have to fit it somewhere within the 1 penny to $50, and that's why it breaks down to a larger amount per day.
Right. Okay, and then, just for my knowledge, where did they have to register with the Department of State, right?
Correct.
Does the Department of State report them to our commission that they've been violated?
They
Violated the regulation?
They certainly have the discretion to communicate with this commission. It's my understanding they do from time to time, and they may have in these particular cases.
We've actually initiated an ongoing administrative process now where at the end of each quarterly expense reporting period after the forms are due, we get a list from the Department of State comparing who has registered as a principal and who has failed to file the reports.
Okay.
Then we take that report and we proceed with it, sending out the warning notices under the ethics law. So too with the registrations. At the end of the registration period, when the new registration period begins, we get a report from the Department of State of individuals who have not paid the appropriate fee, who have not sent their picture in as lobbyists. And once again, we proceed, once we get that delinquency report from them, and send out warning letters. And then if there's no response to those warning letters, it can proceed to a matter such as you have before you today.
Okay.
But that is an ongoing process that we have now established.
And these communications would be with the investigative division as the enforcement arm of the commission.
Yeah, okay, good. So they register there and then we have the enforcement.
This is a process that's taken several years to put into play because once the lobbying law was passed, the Department of State had to first get their registration and reporting systems up and running, and that took several years actually, and then we started to get the reporting process in play to work with us.
How many investigators do we have?
Right now we have 3 investigators in our Pittsburgh regional office. We have 3 investigators stationed here. We have 1 vacancy, and that doesn't include Mr. Caruso, who doesn't do much field time. He's the supervising investigator. So we actually have a total of 6 plus Mr. Caruso. We have 1 vacancy at this point.
Further questions? I believe there is a motion, and I believe there was a second. Any further comment? If not, all those in favor of the motion as presented, kindly respond by saying aye.
Aye.
Are there any opposed? There being none, it is approved as well.
Excuse me, Mr. Chairman,
Yes,
are we
sir.
likely, this is new, are we likely to get more of these?
Oh, yes, these were the second and third
Yeah.
of this type of case that's come before the commission. The process actually allows for the investigative division to send warning letters, which of course you're aware of, giving grace periods for compliance. So the cases that will be coming to you will be those for which the grace period was ignored or for some reason compliance was not achieved.
Okay, thank you.
The next matter on the agenda is a approval or ratification of the settlement in the Stilt matter. I'm sure all the commissioners remember this. Mr. Stilt brought an action against Mr. Contino in his official capacity as executive director, as well as against now Governor Corbett, but then as Attorney General in his official capacity. The purpose was questioning the First Amendment right and to the publicity or the relinquishment of information, and the court, Federal District Court, found that we were in violation of the First Amendment. It was appealed and the injunction was granted and upheld, and therefore under the statute the complainant is entitled to counsel fees. That was negotiated with our attorney, who at the time was Howard Kirk, who was the Senior Deputy Attorney General for the Commonwealth of Pennsylvania, who was defending the case on behalf of Mr. Contino and Mr. Corbett. They reached a settlement in the matter, and I propose the ratification of the settlement as to Gene Stilt's attorney's fees and costs. Pursuant to the Sunshine Act, official action as to litigation-related matters shall be taken in an open meeting. With regard to the matter of Stilt versus Contino et al., I move that the Commission ratify the settlement agreement and release, providing for payment of Gene Stilt's attorney's fees and costs in the total amount of $33,913 for the litigation in both the United States District Court for the Middle District of Pennsylvania under docket number 109CV0524 and the Third Circuit Court of Appeals under docket number 093016, and that is my motion. I should say parenthetically that this amount is covered by the Employee Liability Insurance Program, so there are no funds taken out of either our budget or the state's budget. That is my motion. Is there a second to the motion?
Second.
And it has been seconded.
I have a question.
Certainly.
Does this mean that hereafter, if, for example, a person would contact the Ethics Commission about an individual who they felt had done something wrong, that person can issue a news release now saying, I turned this person's name into the Ethics Commission? Is this what this now means?
Yeah, so a complainant can now speak freely about having filed a complaint with the Ethics Commission.
Didn't we take this up in York?
Well, we've taken it up a number of times, and under the statute, as I mentioned, the complainant who brought the action is entitled to counsel fees. So there was then a submission of his attorney's fees. There was negotiation with our lawyer, who was the deputy attorney general, and they finally reached this figure as a settlement. All we're doing now is ratifying that it can be paid out of and the insurance company obviously agreed to it as well, because they're paying the tab. With that, the motion is standing. There is a second. All those in favor kindly respond by saying aye.
Aye.
Any negative minded? There being none, that is approved as well. There's an opportunity for any member of the public to address this commission at this time. And looking over our vast audience, I don't see anyone who wishes to make comment. Therefore, I would be pleased if the commissioners had no further questions or comments to entertain a motion to adjourn.
So moved.
And it has been moved and seconded, and I am sure there's no opposition. So we will adjourn the public meeting and move into our executive meeting. However, if you wish, we'll be pleased to take a 5 or 10 minute break before we cover those items.